which is the part of the prescribed criminal procedure of this country. Earlier, we had criminal procedure of 1973, which has been now replaced by the Bharatiya Nagarik Suraksha Sanhita 2023, which is the new prescribed criminal procedure in our country. And the cross examination is the part of the main trial of any criminal proceeding which is being placed in the court of law for trial. We will be discussing about the cross examination in detail, its legality, its way, its process, its scope, its limitations. But before I go to such discussion, I need to establish certain kind of understanding of pragmatic nature, of practical nature, that what exactly cross examination is. In the practice of law, or in the practical approach of law, I would say that the understanding of the law letters is very different from that of written in the bare laws. There may be one sentence written in some bare law which has general meaning, general construction of meaning in different way. But when you visit the court of law for such procedure, so you may find slight variation from that of what has been written in the bare law. And therefore, I am of the opinion that understanding the pragmatic approach of the criminal procedure prescribed in our country requires certain kind of hands-on experience. That is one part of the story, that the hands-on experience is always given in the court of law. But in developing time of legal profession, we are facing different dimension of development of the profession, which is the practice in boardrooms, which is the practice behind the court machinery. My idea to share this thought is that now in present scenario there are two kinds of hands-on. The one hands-on is in the court, and the another hands-on is in the firms, those who are preparing documents for functioning the courts. If you go back to the 90s, initial 90s or even later 90s, you will find that the documents, those which are presented in any court of law for proceedings, those documents are prepared in manual way. Even there was the existence of computers, but the technology and the support system of the court functioning arena was not such developed that it can attract something which was done beyond manual operation. Now, what happens when you switch to the 21st century? You see that not only the technology, not only the system, but also the preferences of the courts are changing day by day. It might be the requirement and stress of the legislation. It might be the requirement and stress of the population society. That is the since the litigants are the major stakeholder in the court proceeding, or there might be the preferences of the government of the day, because they are also the government of the day might be interested in global ranking, global networks, global trade, and those have crucial connection between the court functioning system in our country. If you face the court functioning directly, as I pointed out, that you will face two kinds of documentation. The one documentation is which is prepared at the hand, and it is utilized in the court system as conventionally as possible. The second part is that there are firms which are not limited to the corporate exposure, which are not limited to the corporate functioning, which are not limited to the corporate drafting and appearances. The firms are working more on criminal side of the practice. You see the documents relating to the criminal code functioning. Ready-made documents are available on the, of course, for a price, and that can be altered, that can be readily made available before the court only when the litigant is appearing. There is no concept of beforehand timing in utilizing the firm's specialization in criminal side practice in present day. Why our program, or why this program, why this introduction to cross examination, or this subject of cross examination becomes so important from the whole big piece of the Bharati Nagrik Suraksha Sanhita, which is the prescribed criminal procedure. The law contains 531 sections, is spread over into the large number of chapters. Why this cross examination becomes so important? Because now, as a new entrance to the profession, you have two eyes to look on. The one that you want to perform the work for yourself, for your client, for your stake. And secondly, you want to plan the works into pieces, you prepare works and you sell it to the others. These are the two sides of the market. Only in criminal proceeding, I'm telling you. That's why I took the example of initial 90s or later 90s. That at that time, the firm-based lawyering was limited to the corporate exposure, the banking practices, the trade practices, the competition segment. This was never a concept that the firm's practice was majorly utilized or commercially utilized in criminal courts functioning. The lawyers of the criminal courts, or those who were preferring to work on criminal side, they were not so curious about taking firms' help. They were of the interest that they would create the piece of work by themselves. Now the time has changed, and you have two opportunities, you have two kind of experiences, you have two kinds of anticipation of results. Now you see, suppose if we try to segment the BNSS, Bharati Nagrik Suraksha Sanhita, which is the prescribed criminal procedure presently in our country, if we try to segment it into parts, into major parts, in fact, because there are numerous parts and we will be failing in segmenting it correctly, and therefore I'm taking only major parts. So let's say the BNSS major parts starts from the registration of cognizable offenses to the police station or by the police officer. So that is one part where the investigation starts. And then when the investigation is completed, the result is having two notions. One, if the offenses will be found or evidences relating to the offenses will be found during the investigation of the police, the mandatory police report will contain charge sheet. And if there have been no findings of offenses during the investigation, then the document which will be submitted by police to the court is called final report. So if the term final report comes to your cognizance, to your knowledge, that means that after registration of the FIR, during the investigation, there have not been trace of any evidence by the police. Or to put it very simply, police could not find out any evidence with regard to the offenses registered. And therefore, police submits the police report, final report. So if the offense is there, the report is called charge sheet. If offense is not there, the report is called final report. This is, let us take this as one segment of the criminal procedure. The second segment is the court takes cognizance after the charge sheet is received. Cognizance in all cases is taken by magistrates, and if the case is thereafter triable by the magistrate, it will be referred to the magistrate. If it is triable by the court of session, it will be referred to the court of session. Then the trial will be conducted, and trial had several stages. I will discuss those stages. Let's take this as the second part of the procedure. And after the trial, the third part is the judgment. What decision the court is reaching at, and how that is going to be communicated. How that decision of the court, which the legal people call the judgment, how that is going to be communicated. That has a technical aspect. If we segregate these three parts, the trial is the only part. Remember my words. If we segregate criminal procedure in such three pieces, trial is the only part where all the stakeholders of the ecosystem participate. All the stakeholders of the ecosystem participate. Trial is the only stage, only segment in the criminal procedure where all the stakeholders of criminal justice system will require to meet at one time or another. In investigation, the first segment, there is no court, only police, witness, informant, victim, crime scene. You go to the trial, police has to come for what? Charge sheet and information has been given by the police. Victim will come for a statement. All witnesses will come for different kinds of examinations. Police will come even for the examination. Different kinds of stakeholders will be there. Court itself is deciding the case during the trial. So if the forensic examination has taken place, definitely the experts will come. If there is further need of any kind of expertise, then experts would be called as a special status witness. All the stakeholders, you cannot even think that what all, even the if the accused in judicial custody, the jail authorities would appear. If the accused is in the police custody, the police authority will appear. There is a defense counsel, there is a prosecution. Trial is the only stage where all kinds of stakeholder would come. And therefore, somebody is saying that I'm not audible properly. Is this so? Harpreet ji, now I'm audible. I'm sorry, I could see the message slightly late. Okay, it's good. All right, perfect. And somebody is asking that who all are the stakeholders? Stakeholder is the court, police, witness, informant, victim, medical practitioner. These all are the stakeholders of the criminal trial. All right, friends. So the trial involves the all stakeholders of a criminal proceeding, and therefore this is the most important step or segment of criminal procedure during a case which is being inquired into. Now, in the same way, when we stressed that trial is the most important part of a investigation, in the same way, you again come into the trial and break into the pieces, break it into the pieces. And now what is it? In trial, the first statutory function If you are interested, you can note it down, those who are interested. What is the first statutory function in the trial? The first statutory function in the trial is the framing of the charges. Framing of the charges. That is the first and mandatory statutory function. So when the charge is framed, then the opportunities for prosecution and defense is appropriated accordingly for their submission of evidences, for their counters of the evidences, for their different kinds of arguments. And then at one stage, it comes about the examination. There are three kinds of examinations. There are three kinds of examinations. The first examination, which happens as per the first appearance of all kinds of people, those who are invited into the proceeding. Then the cross examination takes place. So the first examination is called examination in chief. It is further followed by the cross examination, and then re examination takes place. These are the three examinations of the witnesses which will take place during the trial. And then the court reaches to a decision. Court draws the legality of all the submissions, and then it reaches to the decision, and judgment is pronounced. So as the trial is the central idea of the whole criminal procedure, in the same way, the central idea of that trial is the cross examination. I hope I have been able to make a foundation of understanding that what exactly cross examination is and how it is most relevant during a criminal trial. I conclusively said that if we segment the whole criminal procedure into parts, we will be able to easily arrange it into three parts, in which the trial would be the most important part. And then in trial, the most important part would be the cross examination. Now, if you go to the series of the examinations, I am writing in the chat box about the series of the examinations so that it will be easy for you people to understand. Examination in chief. I hope it is all going well for all the participants. If anyone is having any issue, please let me know. If you have any doubt or any of these statements which could not get proper elaboration, proper interpretation, please intervene. If you are able to follow me, then it is excellent. If you are not able to follow me, let me follow you. That's great. I will write three other things in the chat box. I will take just 20 to 30 seconds. Now I am writing that which party conducts which examination during the trial. So examination, it is written in the bare itself. Examination in chief, the party who calls the witness. cross examination opposite party. Re-examination the party who calls the witness. Yes, it is the established practice that the examination in the series of the examinations, the examination in chief will take place first, and this will always be done by the party who is calling the person. Suppose one witness is called during the proceeding and prosecution has called that witness. There is no fixed party in the criminal trial. Suppose prosecution has called a witness and therefore the examination in chief will be conducted first, and who will conduct it? This will be conducted by the prosecution itself. Witness is called by the prosecution, and then the prosecution will conduct the examination in chief. That will be readied written by the court itself, by the reader of the court itself, and then a copy of this will be given to the opposite party. So if the witness has been called by the prosecution, of course, the opposite party is the defense party. And then defense would conduct the cross examination. Again, those statements would be recorded by the court. And after this, after the conduct of the cross examination by the opposite party, again to accumulate all the things in a proper way, the party who conducted the examination in chief will conduct the re-examination. And in the same way, if the witness is called by the defense, there may be list of witnesses which are to be called by the defense party. So in such case, the examination in chief will be conducted by the defense first, then the cross examination will take place by the prosecution, and then again the re-examination will take place by the party who has called it, that is the defense in this example. Now, this is the legal procedure which has been prescribed in the law, but when you try to synthesize it into the concept, if you try to understand the synchro of all the three examinations, then what can I say? For examination in chief, I say it is thesis. For cross examination, I say it is antithesis. And for re examination, I say it is synthesis. It is synthesis. Yes, it is in the chat box. Harpreet you were saying they will conduct it varies from facts. Yes, it varies from the facts. I will come to that. I'm only clearing the foundation part. In a series, I will come on the facts and circumstances. I will even come on a single statement made by a person, how it is treated in the court proceeding. You just don't worry, give me some time. Let me establish it is equally for all participants. And then the beautification part will be sum up in the last session. Thesis, antithesis, synthesis, examination in chief, cross examination, re examination. Why I am saying it? In thesis, always there is a scope of opening of the argument. Opening of the argument. In antithesis, to make the counter against the argument. And synthesis to accept and conglomerate the arguments of thesis and alterations attempted by the antithesis. These are the three concepts on relying on which I was backing it to the concept of examination in chief, cross-examination, and re-examination. Now, what you do if you see a document containing the questions asked in any of the examination in chief, and then question asked in subsequent cross-examination, and then questions asked and responded in subsequent re-examination. If you see these questions into a document, you can never guess that what is the synchronization between all the three. And the court will choose which one of them for their correct decision. Neither I am pointing at a great variation in Indian criminal procedure, which was available in 1973 law as well and 1898 law as well. It is again present in 2023 law as well. What is that gap is there is no bind on the court that court should infer only from either examination in chief or in a cross examination or in re-examination. There is no bind. Law does not prescribe that after conduct of the trial, the court for the purpose of taking decision will utilize the portions that were discussed, that were reached at in examination in chief or in cross examination or in re-examination. The court is absolutely free to choose to make the synchro and to reach at the decision by involving the whole procedure which has taken part during the trial immediately after the framing of the charges. Once the charges are framed on the basis of the documents which are submitted by the police with the copy of the FIR. But after the framing of the charges, whenever court steps into any of the procedure, if it is submission of statement, if it is submission of argument, if it is appearance of some of the witnesses, the court prepares a different document for every appearance, for every submission, and for every argument. And on the basis of that, the court derives its own decision. And therefore, it is generally understood that courts, when they are functioning on the basis of the law which has been prescribed, they do not alone function on the basis of law that has been prescribed. They are absolutely guided by the law that has been prescribed, but they actually reach at the decision by the submission of the arguments, evidences, documents, and other related aspects. And therefore, this is the reason that in the hierarchy of the courts, where if we generally divide the hierarchy of the courts in our country, the apex level is at the Supreme Court, then every state is headed by a high court, and then there is a district and sessions court in every district, which is generally called the sessions division. This hierarchy might be, however big it is, however important it is, however relevant it is, however wider jurisdiction it carries, but the most important phase of a litigation is the trial, which is always except some exceptions. There are certain things where High Court may convert itself into trial court. There are some civil proceedings where the High Court is empowered to convert itself into trial court. Except those things, the total trial procedure is done in the district and sessions court, which generally may be the court of the first instance. And despite being lowest in the hierarchy, it reacts as the most important stone in the whole complex. Even the matter reached to the Supreme Court after a decision from relevant hierarchical decisions. The Supreme Court is in certain aspects bound to behave within the limitations that has been set forth by the district and sessions court during the trial of the case. Now, the second part of the deliverances. Reddy Saab is saying, can you please explain this again, sir? Which part is required to be explained again? If you please could tell me. I am proceeding, you can intervene in between. Synthesis, okay. Okay, I will. Now, there is a basic concept of cross-examination that whatever I told you, it is the concept, it is the observation of long experience, it is observation of seeing number of cases, it is observation of seeing number of files into one case and into different cases. But now I am presenting a
अगर
basic idea
क्लास में तो
before you.
तुम मेरा कान ना खा जाओ चलाते हुए गाड़ी.
Mr. Mishra, please mute yourself. Thank you. So the basic concept of cross-examination is presented on the slide. Let us read it and let us break some small parts into it. Cross-examination is perhaps one of the most fundamental components of an accused's right at the trial. Through cross-examination, the accused is able to challenge the evidence and assertions against him. Challenge the evidence and assertions against him. Through cross-examination, lies can be exposed and truth advanced. Effective and meaningful cross-examination can vindicate the innocent. Despite the intrinsic value of this constitutional right to ensure justice, numerous people accused of crimes are denied effective cross-examination in their cases. Some are denied this tool of justice because of the courts, others because of their advocates. Cross-examination is one of the most difficult trial skills to master. Few attorneys have the raw talent to conduct an effective impromptu cross-examination. Most lawyers struggle with cross-examination, but besides talent, there are numerous factors that impact counsel's conduct of cross-examination, including training, experience, preparation, organization, creativity. To an extent, courts have restricted cross-examination in some cases. Now, to make this better understandable, I am taking a new example that how the cross examination is connected to justice directly, how the cross examination helps in discovering the truth and saving the person who is being wrongly framed, and how the courts have been able to somehow restrict the scope of cross examination. Dear friends, you must note and you understand that If one advocate who is appearing before a court of law, that it depends totally on the capability of that advocate, that court will run by which fashion. If an advocate is appearing before the court of law and he is not even aware of the basic laws, first. Second, if he is not aware of his own privileges, and third, if he is not aware of the etiquettes and mannerism that has to be followed in the court of law, that advocate will never be successful in getting over the court. Such advocate will always be subordinate to the court. So when you have to, as an advocate, as a trial practitioner, if you have to face to the court, what the basic need is, you should be aware of the basic law. You should be well mannered. You should be knowing the etiquettes, and you should be knowing the privileges of an advocate with regard to the particular function for which you are appearing. I am not at all talking about the general privilege of the advocate. The particular function that you are appearing for an examination. For an example, sorry, if you are an advocate of defense and you are appearing during the trial, you must be knowing that what limitation you have and what privileges you have. If you are an advocate of prosecution, then your privileges and other things will differentiate. So, as a lawyer, by understanding the proceeding, you need to make yourself very much compatible with these things. Second part, how the real truth is discovered in the cross examination, and how this is referred as synthesis, since some participant has requested to repeat the concept. I'll repeat it. Suppose a person has been called as witness. He is called by the prosecution. Prosecution asked him certain questions during the examination in chief. So prosecution asked that, what all did you see during this commitment of crime? The person responded to the prosecution. In which phase? During examination in chief. Responded that, I saw that A is coming from opposite direction, and after seeing B, he just opened up the fire, bullet fire, and he fired with non-stop, and then the B fell down and A is, ran away. This is noted. This will be exactly noted down during the examination in chief. Now the defense will come for the re-examination. Sorry, cross-examination, which we are studying here. Now the defense will come and defense will ask, for an example, just I'm setting the example. Defense will ask that, okay, you said in the examination in chief that the A was coming from the opposite direction. After seeing B, he just opened up the fire, bullet fire, and he keep firing non-stop, and consequently the B fell down and died, and then A ran away. This he told in the examination in chief. Now the lawyer who is doing the cross examination, that is the defense lawyer, he will ask, from which direction you were coming? from which direction you were coming. The person who says that A was coming from opposite direction. So he will ask from which direction you were coming. So let's say he may come that I was on the roadside. The road is east-west. I was coming from the east and going to the west. Okay. The person said in the examination in chief that A was coming from the opposite direction. So if this person was coming from the east and going to the west, it means that A was coming from the west and going to the east. So cross-examination lawyer will not ask any further question. Suppose I'm just taking example that how it goes. Cross-examination lawyer will only ask only one question, that you have said in the examination in chief that you saw A firing on B and he was coming from the opposite direction. And you have to tell in cross examination that from which direction you were coming. And he responded, I was coming from the east going to the west. Perfect. The cross examination is over. If only this much fact is there, the cross examination is over. Defense will say, okay, you may go on. Now, in re examination, the prosecution has to do whatever he wants to do. Another witness comes, second witness comes, and he says that I got the information over a telephone that A was coming from Rampur. Next witness come and he tells that I got the telephonic information that A was coming from Rampur. Further cross-examination, re-examination of that person will come. Cross-examination, defense will ask, you have said in the examination in chief that A was coming from the Rampur. Where is the Rampur? And in which direction from crime scene it is? In which direction from in crime scene it is? Suppose it is in the east of the crime scene. The person will say it is in the east of the crime scene. Person will be released from the liability. He will go, okay, further cross examination is over. In first cross examination, the first witness accepted that the person who opened up the fire was coming from west direction and going to the east. And in the second examination, the person admitted that he was coming from the east. He was coming from the Rampur. Rampur is in the east of the crime scene. He was coming from the Rampur. This is the gap. No need to prove. No need to prove that whether Rampur is exactly there. No need to prove that whether he was actually coming from the west or east. What is the game in this is prosecution has to prove its case beyond reasonable doubt. Now there is a reasonable doubt. If reasonable doubt is there, benefits, if any, shall go to the accused. What was the basic liability? What was the basic duty, basic clue of the defense in this case? Only to create reasonable doubt. In maximum of the cases, as a lawyer of defense capacity, it is very limited that you have to give evidence of defense of your client. Rather, first of all, you have to create the reasonable doubt. You have to create the reasonable doubt on the story of the prosecution. And doubt will come, its benefit will go to the accused. This is the general principle of the law. And therefore, This is the, suppose anybody has been framed wrongly in any case. During the registration of the FIR, police did not listen. Then investigation happened. Again, police did not listen. Police asked for some bribe that you give me so much amount of money, I'll just make you free. Person did not ready. He did not give any money. Okay, go ahead. Charge sheet filed. Court started the trial. Now you come to the cross examination. If you were framed wrongly, I am telling you for the guarantee that you cannot set the story of any futuristic event. For sure, if you have to be examined on any topic orally, for sure the synchronization that you have to be examined at a future date, you cannot predict it today. And if there will be more than one statements of more than one people, definitely there will be the development of a scope from which the doubts would be created. And that doubt is going to save the person who is being wrongly framed. This is the discovery of the truth. This is the discovery of the truth. Now you come to the synthesis part, which a participant requested to repeat. That examination if in chief opens up about the all opening kind of arguments. Therefore, it is called thesis because the arguments are being placed for the first time, statements are being placed for the first time. Then in the cross examination, there are usual practice of making counters against the arguments advanced during the examination in chief, and therefore it is called antithesis because it is against the basic premise. And then if any of the part of the basic premise, any of the part of the counter made, if it is acceptable, then such part would be segregated. The basic premise of the examination in chief will be compiled, and then this will convert itself into the re-examination. This is called synthesis. So synthesis is basically conglomeration of the basic argument, basic premise that has been made, and all the further submissions which are being adjusted, since the cross examination is the process of truth of discovery, discovery of the truth, and therefore some things will come out during the process of the cross examination which will be eventually accepted by all the parties, and therefore it will be added to the first premise, it will be added to the prosecution's story, and therefore it is called synthesis, synthesization of the things made earlier and advanced later. These all to be synthesized together, and this is called synthesis. Nituji is saying not clear which part.
So when you was till now it was clear, sir.
Okay, okay, all right. If you have any question, you can ask. Now the next part is that we have certain restrictions on the scope of the cross examination. So if you are going into any legal procedure, you must know that what is the limitation. If you are aware about the limitation, then you know your own power, that what maximum you can do. So knowing the limitation in any criminal procedure is must. Now you see, courts and the rules of evidence provide some limitations on cross examination. There is a maxim written on this slide, and there is a meaning of that maxim is written here. The second part is very important in this. Protect witnesses from harassment or undue embarrassment. What is the challenge while conducting the cross examination? This part would attract, I will just elaborate it. If you talk about the scope of the cross-examination, it should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility. The court may allow inquiry into additional matters as if on direct examination. Then there is a stage of leading questions. Leading questions should not be used on direct examination except to develop the witness testimony. Ordinarily, the court should allow leading questions. But how the court will allow the leading questions, what are the leading questions, this I will tell you. Now, you see, the protection of the witness and protection of the person who is subject to the different examinations during the court proceeding. This is something where the restriction, or this is the new challenge of the cross-examination procedure is before us as a participant of criminal justice administration system. In this, what happens recently, there have been different guidelines of Supreme Court where the protection of witness is becoming important subject matter, and legislative act is also being considered for this purpose. So for the protection of the witnesses, there will be law in times to come in your country. And since the deliverance in examination in chief is very much material for the cross examination and the consequent re-examination, and therefore the person who has been examined chiefly must be available in the same synchro for the cross examination. So suppose examination in chief is taking place today and cross examination has to take place after 2 months, then within these 2 months, who will take the responsibility of security of such witness who has been examined chiefly and cross examination is remaining? So this is one of the challenge. This we need to understand. Second part is that what is leading question? So let us come from the legal language out. I am not going to discuss leading question in legal shape because it will rather confuse you. I am just telling you the very basic part of the leading questions. Suppose I have to ask you that whether you have completed your law graduation. Suppose this is my objective. I want to ask it from you, but I don't want to expose that I asked this to you. If somebody can understand Hindi also, मैं आपसे पूछना चाहता हूं कि आप लॉ ग्रेजुएट हो कि नहीं, लेकिन मैं आप इस बात का प्रदर्शन नहीं करना चाहता हूं कि आप लॉ ग्रेजुएट हो कि नहीं, ये मैंने पूछा। किसी और तरीके से मैं इसको पूछ लेना चाहता हूं। वो किसी और तरीके से पूछने में जितनी बातें मैं करूंगा, वो सब लीडिंग क्वेश्चंस हैं, और असली बात जो होगी वो उसी बीच में कहीं मैं पूछ लूंगा, आपको पता नहीं चलेगा। फॉर एन एग्जाम्पल, if I have to ask you that whether you are a law graduate, and I don't want it to be exposed that I asked you that whether you are a law graduate, I just wish to ask it in a hidden form. So I'll first ask you, okay, what's your name? All right, all right. Which college do you belong to? Okay, okay. Don't you study political science with your law? Don't you study sociology with your law? Are you scoring more in legal subject or in humanities or management subjects? These questions, this will deduct yourself. Please mute yourself. Admin, please mute himself. I do not have the rights.
So direct IAS नहीं, क्या मालूम कहीं का ऐसा बोलो मुझे बोल ऐसा करते रहो
Mr. Tajuddin sir, please mute yourself.
एक्चुअली कमिटी है करना, और कमिटी को नई कमिटी बना 1 महीना हुआ करते तो पैसे कहाँ ही है था, इनके पास ही रख लेने, इनके पास रख ले कहीं तो भोंडल लाखा हाँ अकाउंट में झाल्याने सर का कोण पूछना रहा जी वक्त
Please mute yourself.
1,000 रुपये रख ले जाओ सा मस्जिद आके बैठे
Admin, please mute himself or give me the right. It's very disturbing. Okay. So leading question is the set of questions which are asked to get answer of some other question, which is considered the main question or prime question. I hope you have been able to understand it. The next is the preparation and conduct of the examination that I have talked you about, that how the charge sheet is submitted and what are the general precautions which are taken during the cross examination. There are two basically approaches. However, it is written that types, but since the categorization is not statutory, and therefore we will consider it as the approach. There are different approaches of cross examination, and the one approach is called the constructive cross examination, and another approach is referred as destructive cross examination. So it basically depends on the priority of the party who is conducting. Party means the advocate. Either it will be the prosecution party or it will be the defense party. It depends on their priority, that what approach they are following. If you talk about the constructive cross examination, this approach focuses on building your client's case by highlighting favorable facts and establishing key points. If you talk about the destructive cross examination, it aims to undermine the witness's credibility and testimony, exposing inconsistencies, biases, or weaknesses in their account. What actually happens that if the approach of the client is on constructive cross examination, then what he does, that he actually creates the sharpening of his own evidences. He submits he actually relies on his own arguments. He actually relies on his own submissions, own evidences, and therefore he prefer to create the legal dictum on the basis of the arguments and evidences submitted by himself. I mean, the party who is submitting it. And if we suppose I am appearing for the party and I am having limited scope of evidences, I am having limited scope of cross examination, I am having limited scope of relying on my own evidence and documents, then what you have to do, you have to create reasonable doubt on the story of the prosecution. And then in such cases, what you have to do is, you have to, for creating such reasonable doubt, you have to adopt the destructive cross examination method, where you do not put your own advance evidences or documents or submissions. Rather, you try to counter, you try to weaken, you try to make them fail the submissions, the arguments, and the evidences of the party who has already put it before the court of law. So, this is the way of doing constructive and destructive cross examination. I hope there is another one lecture tomorrow. I will discuss these things in detail and the frequently asked questions about the cross examinations and some other concepts, some legal provisions, and some cases I would be discussing in tomorrow's class. Till now, it is all done from my side. If you have any question, if you have any feedback, anything that you wish to say, you can say. Or if you could not get proper understanding. That also is welcomed. I will try to reform myself. So the floors is open.
Yes, sir. I just want to ask one thing that
Yes.
if we have any document or any proof available with us as a defense counsel,
Mhm.
and which is not a part of the charge sheet, but we have that any photograph or any proof. So while cross-examining a witness, can we put that document or a photograph or whatever proof we have, which is not a part of the charge sheet, before the witness to say that this is the real truth or this is the photograph which you, which on which we can prove the innocence of the accused. So can we put while cross-examining whatever document or whatever proof we have, but it is not a part of the
Okay,
charge sheet? Yeah.
I understood the question. See, whenever the case is opened for argument, that means after the framing of the charges, the admission statement is recorded from the side of the person who has been charged, that is the accused. And thereafter, whenever the court says that court is now open for the documents of the prosecution and defense, you have to provide the list of all the documents, all the evidences that you wish to add additionally, and also the submissions that you will make in future. All such estimates tabled into one table of containing one table of content, by mentioning the number of pages, number of notings, number of advances. These all you have to synthesize into one piece of document. And even if you are the prosecution or if you are the defense, you have to submit it before your argument starts. Secondly, there will be the necessary statutory steps of giving this document to other party as well. Whatever has been submitted from the prosecution, defense may examine it in the court hour, and defense is entitled for the copy. In the same way, whatever has been submitted from the defense, the prosecution is entitled for a reading, and then prosecution will get a copy. So there cannot be introduction of new evidence during the examination in chief, cross examination, or re examination. Examination in chief can also happen centrally on those points which all have been submitted during the written pleadings. And if you have to go beyond the submissions of the written pleadings submitted before the court of law, then you need to have a fresh permission. For that, a fresh notice will be issued to the adverse side. Then the adverse side will be given reasonable opportunity for hearing, and then you will be allowed to submit such photograph and all. There is another important part in this, in new BNSS actually. Earlier it was not there. Now in Bharatiya Nagrik Suraksha Sanhita, which is the new criminal
हाँ
procedure,
पैसे सुना दे जाकर डबल और
if you will submit,
हाँ
suppose a photograph or piece of
वीडियो
letter or
वेबसाइट रहा था
something
मैं दोस्त का
in this
कमिटी
way, as a matter of new
सभा का हमारे
document,
बाबा का काम करा था हमारे पास भी
this
काम
will
करता बेटा
mandatorily go for the forensic examination.
तो बेटा सीधा सुधार वो बेटा यहाँ
This
जरा
will
उसे क्या
mandatorily go for
तो
the forensic
बहुत
examination,
होशियार है मैं हमें ही
and
नहीं
then
कर
only its legality will
उसका
be
बोले
established.
खा लेना
So
मस्त
this
काम
is
करो बोल
the thing. You cannot, give any fresh evidence or fresh photograph or such series in the stage of cross examination. You have to follow certain steps.
So meaning thereby that when cross examination of all the PWs are done, and then that stage comes that we can file a list of documents or whatever we want to rely on.
Yes, you can file, that is called the supplementary submissions. For
So-
supplementary submissions, all the previous arguments would be over, and then you will be given again another opportunity for such making such submissions orally.
Okay. Okay. And one more thing I would like to ask that, you know, when the charge sheet is submitted, there are list of witnesses in that. So if I am appearing on behalf of a complainant on whose instance an FIR has been registered, however,
Yes.
during submission of charge sheet, I found that there are certain important witnesses which have not been made, which are not included in the list of witnesses. So, can as a complainant, I mention it before the court, or I can call my witness who is the most important and credible for my case?
Let me correct you by a slight amendment.
Yes.
You are not complainant here, you are informant here.
Informant, yes.
Yes,
Right.
because if the case is cognizable and FIR
Yes,
has been
because an FIR is
registered, there is
registered.
no
Yes.
scope. There is no scope of
Yes,
complainant.
yes, that's right.
So that is the informant. And in the sessions trial, the second most important stage is the opening argument on behalf of informant.
Hmm.
And when the examination is when examination as to first information report takes place in sessions trial, at that very stage only the informant has a scope to make his submissions. Beyond of that has been submitted by the police. And therefore, if you have fresh statement and witness to add, so the examination of the informant, which is called at the very first stage of the sessions trial, you can submit there. You can make the application of this regard, and then definitely court will allow you. This is the statutory right, and the informant can even add the number of witnesses there.
Okay.
At this stage.
Okay. Okay. Thank you.
Sir, good evening. I have one question, sir.
Yes, please.
Sir, my question is this, sir. You said that you have to seek permission of court before putting any evidence. Suppose in cross-examination, I want to ask a few questions which is already published in government gazette, like act. It is related to some act or government regulation. So, is it required to seek permission for that such thing also? That is already in public domain, sir. That is some act or some regulation which may be related. I think suppose a case is like that. The 2 or 3 act are applicable on that.
I have understood your point. Let me answer. See, I did not say that whatever you have to ask in the examination that you need to submit, that you did not require to submit. You require to submit the total steps that you will follow, and total evidences and documents and arguments, those which are supporting your examination in chief or cross examination or re-examination. So that outlined structure you are required to submit beforehand, and not the exact question. Yes, when the examination in chief happens on the very same date, when the examination in chief going to start, a copy of certain questions is given to the opposite party, that this I am going to ask, but that also contain the principal questions only, and any subsidiary question that is open to be asked. So suppose I have written in the query of the examination in chief, suppose question number 2, I have written that I will ask that the bike you have purchased on 23rd March 2021, what was the exact price that you paid? Suppose this I have to ask, and this I have written in the advance submission that I am giving it to the court. This copy has been given to the opposite party. While asking it at the actual examination in chief, this question definitely I will ask because it is written there. Then I may ask that, okay, what mode you have adopted for the making the payment? This was not written in the document that I have submitted, but I will ask this and this will be allowed. Now there is a scope. If the examination in chief is in progress from the prosecution side, now it is the liability of the defense that if in extended form irrelevant questions are being asked, the defense can intervene and defense can request the court to stop and not asking such question. Defense will tell that this question is not relevant. This question is illegal to ask. This question is privileged. There are certain things. So this is the art of conducting trial that you can learn only. I generally say to my all dear students, sometimes people ask me that how do I learn this, that what question may be extended and may not be extended. I said them There is a simple way. You just go to one of the busiest sessions court of a city and you just watch 60 trials there. Simply. You do not ask a teacher. You do not ask a rule book. You do not ask a judicial decision. You simply search a busiest court like Delhi. Now, numerous cases are listed there. Just choose a sessions court, go stand inside one corner in uniform so that police wala will not take you out, and just watch 60 trials in that court. Maybe 2 3 trials are conducted in one day, so you may take 1 month or 2 months or 3 months. So just watch 60 trials, you will be most privileged advocate in this country. I hope I have answered you.
Sir, I got your point.
Can I ask you one more question, please?
Sure, please.
Yeah, sir, if there are suppose two witnesses and both are related to each other and they are both interested witnesses, say husband and wife. So in that case, can I request the court that let examination in chief of both the witness be recorded and I will cross-examine both of them together? Because if I
Yes,
cross-examine
yes.
one witness and my defense will leak because there is a possibility that it can be conveyed to the second witness. So can I request the court?
Absolutely, absolutely. You can
So-
request the court that even simultaneous cross-examination and examination in chief may be conducted.
So it's a discretionary power given to the court that he will allow, or as a.
It is discretionary. It is discretionary.
So if it is not allowed, then.
If it will not be allowed, I will go in revision.
Okay. So we can file an application then written, because sometimes
Yes.
there is. Yes.
Yes. Lawyer is everything in the trial, not the judge.
Yes.
Judge has all the limitations. Lawyers are free.
Yeah. Thank you.
Sir, good evening, sir.
Good evening.
Sir, you said before the cross-examination starts, we have to submit all the evidence from defense side, right?
Yes.
Sir, in confrontation, we give them photographs or something and ask them to identify the things. So it's a kind of indirect way of submitting the evidence only, no?
If you are confronting, it will be allowed. If court has any objection on the side of opposite party, then court may fix a different date for such hearing. Suppose in confrontation you showed some photographs, then the photographs are objectionable. Opposite party intervened immediately and said that it is totally illegal and they are not following the law. They have not given any intimation to us, and they are presenting the photograph which even did not have any forensic backup. So in such situation, the court may decide to fix this hearing for another date, and this will be taken on record. Court will ask you to submit an application in this regard that the forensic examination of the photographs being presented will be done.
Okay.
This process will be taken place at this stage, and then trial will differ for a new date.
Okay. Got it, sir. Thank
you. All right. So suggestion for, however, I am little experienced in this profession, and I am having very limited knowledge on the subject matter. Considering myself a slightly senior student of the law, I do not consider myself the teacher. I am still learning. I am trying to learn. I am just giving couple of the suggestions, those who are actually related to the field of criminal trial in any way. Either they are working with the firm, or they are working directly in the court, or they are only being consulted by some people or some institutions. So on the basis of the experience, I am giving you a couple of the suggestions. First suggestion is, which I say generally the cardinal principle. The first suggestion is that wherever, if you want the court to take any decision in your favor, please do not put a paragraph before them. If you are helpless in some condition and you want some help from the court, and then you are telling your irony within one paragraph. The court will hear it, will feel emotional for you, and then just decline the application. What you have to tell you there is maximum of your part to the extent of possibility. If not possible, then you have to leave. Then you are actually helpless. But to the extent of possibility, you should tell the court only the provision of law and judicial decision binding on that court. Whatever you want to get it done by the court, please look for a law. And secondly, what next law for them is, for judges, is the decision of their superior courts, generally High Court and Supreme Court. Just look for them. And in present days, there is excess of SCC online, HIN online, and different other legal databases where you can get numerous judgments. You just type the name of the judge, you will get all the judgments that have been delivered by the concerned judge. If you just use a phrase, suppose a phrase has been used in any judgment, triple talaq, you just write a word triple talaq in SCC online, you will get all the judgments which will have used the word triple talaq. You will get all the judgments. So now the work of lawyers have been, better resourced. So please go for a law and then the judgment. It is better than giving orals of one paragraph before a judge. He will just feel you emotional and then depart. He will not give you the favor. And because of this nature only, you can become surviving advocate. Please do not think that this judge in my acquaintance, he may favor or he likes my smile, so that judge is favoring me. But he may like your smile till he is posted there. Once the transfer takes place, all smile go to vain. So this you have to understand. Rely on the law and the judgment rather than on the smiles. This is the message of the today's class. Thank you so much. I enjoyed your company. If you have further any issue, any help from my side, or anything that I can contribute into your profession, you can reach back to me. Thank you so much.
Thank you
I
so
am
much, sir.
writing my email ID so that it's simply Abhishek Dubey, India. ABHISHEKDUBEY. That is my name. Simply add India to it @gmail.com. Tomorrow it would be better if you read all the provisions of sessions trial in BNSS and then you come for the lecture. Then we will be more comfortable in communicating. So I'm ending up here. Thank you so much. Good night. Take care. Bye-bye.
Good night, sir. Thank you.